This year, Open University Malaysia celebrates 25 years of enriching lives through education. Since our establishment, we have remained committed to accessible, flexible, and inclusive learning, empowering individuals at every stage of life. In conjunction with this meaningful milestone, we are pleased to introduce Rise and Reflect 2025, a special initiative led by the Faculty of Social Sciences and Humanities. This webinar series reflects OUM's ongoing commitment to promoting academic knowledge, public awareness, and professional development. We welcome everyone to join us in this learning journey as we honor our past and prepare for the future.
The Faculty of Social Sciences and Humanities is honored to spearhead Rise and Reflect webinar series 2025, a landmark program marking OUM's 25th anniversary. This series of 25 webinars highlights key topics across the diverse disciplines of the social sciences and humanities, delivered by experienced academics and industry professionals from around the world. The content is carefully crafted to be informative and enriching, whether delivered live or through recorded sessions, to ensure maximum reach and flexibility. Through this initiative, we aim to deepen public understanding, nurture professional growth, and spark ongoing engagement with contemporary academic discourse.
Assalamualaikum warahmatullahi wabarakatuh, and warm greetings to everyone. Welcome to webinar Rise and Reflect 2025, proudly organized by the Faculty of Social Sciences and Humanities in celebration of the 25th anniversary of Open University Malaysia, OUM. We are truly honored by your presence as we come together to reflect, engage, and grow through today's session. We also like to express our heartfelt appreciation to our esteemed media partners, TV IKIM and TV Ikram, for their generous support and collaboration in bringing this event to a broader audience. Your partnership is sincerely appreciated. To all our participants tuning in across various platforms, thank you for being part of this meaningful milestone. We hope the discussion today would offer valuable insights and inspirations. It is now my great honor to introduce our distinguished speaker. We are delighted to introduce Associate Prof. Dr. Muhammad Azam Muhammad Adil, a respected figure in the field of Islamic thought, law, and governance. He is currently the Director General of Institute of Understanding Islam Malaysia, IKIM, and formerly served as the Deputy CEO of the International Institute of Advanced Islamic Studies, IAS, Malaysia, from 2013 to 2022. Dr. Azam holds a bachelor's degree in Shariah and Law from University of Malaya and went to obtain both of his Master of Laws, LLM, and PhD from the renowned School of Oriental and African Studies, University of London. His career spans across academia, finance, and public service. He served as Independent Director of CIMB Islamic Bank Berhad from 2014 to 2016, Chairman of the CIMB Group Shariah Committee 2014 to 2017, and was a Director at IS Malaysia 2015 to 2023. His academic journey includes over 3 decades of teaching at University Technology Mara, Shah Alam. Dr. Azam also contributed as a panelist for the Industrial Court of Malaysia from 2007 to 2009 and was awarded a prestigious Fulbright Visiting Award by the Council for International Exchange for Scholars, Washington, in 2007. From 2021 to 2024, he was appointed by the MINORS as a member of the National Councils for Islamic Affairs, MKI. Most recently, he has been appointed as an adjunct professor at the Faculty of Social Science and Humanities, Open University Malaysia, effective 1st May 2025. Dr. Azam brings with him a wealth of knowledge international experience, and thought leadership that promises to enrich today's session. We are truly honored to have Associate Professor Dr. Muhammad Azam Muhammad Adil with us today. Dear audience, today's topic will dive into one of the most sensitive and complex issues in our legal and social landscape, the conversation of minors to Islam and the result overlap and tensions between the Shariah and civil courts. It brings up important questions about parental rights, the best interest of the child, and how we navigate remedies within our dual legal system. To help us unpack a better understanding these important issues, we are honored to have an expert with us today. So without keeping you waiting, let's hand things over to our distinguished speaker. Over to you, Dato.
Bismillahirrahmanirrahim. Thank you very much, Mr. Nur Bakri. Assalamualaikum warahmatullahi wabarakatuh. And good morning, everyone. First, I would like to thank OUM, in particular the Faculty of Social Sciences and Humanities, for having me on this important conversation. The topic that I would like to talk on is conversion of minors, Shariah, courts versus civil courts. What are the remedies? Today, I will be presenting on a deeply sensitive and critical legal issue in Malaysia, the conversion of minors and the ongoing conflict between the Shariah and civil courts. Our country operates under dual legal system, civil law and Sharia law. And when it comes to family matters involving religion, especially interfaith, custody and conversion, this system often breaks down. Cases like Indira Gandhi and Low Siew Hong recently show us that unresolved jurisdictional conflict can leave children in legal limbo and emotionally scared. So today we ask, what are the remedies? And how can we move towards a more just system that puts the child's welfare first? Let's now explore to the legal framework that governs this issue. We begin with Article 1211A of the Federal Constitution, which states that the Sharia courts have jurisdiction over matters pertaining to Islam. However, this provision does not resolve conflicts that arise when one parent converts to Islam and the other does not. This is precisely where the legal ambiguity begins. Now, we turn to the Law Reform Marriage and Divorce Act 1976, also known as the Act 164, which governs civil marriage for non-Muslims. Prior to the 2017 amendment, there were several gaps in the law. Firstly, there was no clear provision that prohibited the unilateral conversion of a minor child by just one parent. Secondly, if one of the parties converted to Islam, he or she has no legal right to file for divorce until the non-Muslim party does so. Thirdly, child maintenance was limited to the age of 18, regardless of whether the child was still studying. And finally, the Act was silent on joint custody or rights of visit, especially in cases involving parents of different religions. Post-2017 amendment, some key improvements were introduced. Under Section 51, the Muslim party may now file for divorce within 3 months after he or she converted to Islam. Section 95 was also amended to allow the court to order the maintenance right for the child even before the age of 18, provided that he or she is still studying. And Section 106A was introduced, giving civil courts the authority to grant joint custody and right of visits for parents of different religions. Ladies and gentlemen, however, one important proposal, that was Section 88A, which sought to prohibit unilateral conversion of minors, was retracted from the bill. As a result, the landmark federal court ruling in Indira Gandhi in 2018 held that the consent of both parents is required for the conversion of a child's religion. This decision remains highly significant until today. Similarly, under the Child Act of 2001, a child is defined as anyone under 18, but in some states, Shariah laws still allow child marriages below this age with permission from the Sharia court. This inconsistency between civil and Sharia provisions adds another layer of complexity. Lastly, on the international front, Malaysia ratified the Convention on the Rights of the Children, that is CRC, in 1995. The CRC emphasizes the best interests of the child and the right to religious freedom, but in practice, Malaysian courts have not always applied these principles consistently. So, while reforms have been made, significant challenges remain, especially in ensuring that legal protections for children and non-Muslim spouses are upheld across both legal systems. Now we move to the case studies on the human cost. On this slide, case studies, the human cost highlights the real impact on families. Let's look at three key examples. In R. Shubhashini in 2007, the civil court held that the marriage remains under the civil jurisdiction even if one party converts to Islam. However, the conflict between Act 164 and Sharia jurisdiction continues. In the Indira Gandhi's case in 2018, her Muslim convert ex-husband unilaterally converted their children to Islam. The federal court ruled out that both parents must consent to a child's conversion. But despite the decision, one daughter remains missing until today. And this shows enforcement gaps and lack of cooperation between police and religious authorities. And the recent case in Lo Siu Hong in 2023 until now, a similar thing happened. Her children were converted without her consent. The civil court ruled out in her favor, but the Police Islamic Council, MINORS, tried to intervene. This shows ongoing resistance from state religious authorities. Now, let's address the key challenges. First, as outlined on this slide, we face serious jurisdictional overlaps. Different states in Malaysia apply different Sharia laws regarding the conversion of minors. For example, in police, amendments to the Police Islamic enactments in 2013 allow a child to be converted to Islam with the consent of only one parent. In contrast, Selangor Sharia law requires the consent of both parents. This inconsistency across states creates legal uncertainty and raises concerns about justice and the child's welfare. Second, legal ambiguity exists. The age of a child and marriage eligibility differs under civil and Sharia law. Third, enforcement is weak. Even when civil courts rule against unilateral conversions, religious authorities sometimes ignore them. Fourth, there is non-compliance with the CRC. Malaysia has international obligations to protect children's rights, but these are often undermined by judicial conflicts. Unilateral conversions violate CRC under Articles 3 and 14, undermining child welfare and religious freedom. On slide 5, proposed solutions. What are the remedies? It details how we can fix this. To begin, we must address legislative reform. Act 164 or the law reform Marriage and Divorce Act 1976 should be amended to require both parents' consent for a child's conversion. We must also harmonize the legal age of marriage across all states to be fixed at 18 years old. Second, to create special family tribunals. This would include civil court judges, Sharia court judges, and a child rights experts to hear interface custody and conversion cases. Third, to encourage judicial collaboration, where civil and Sharia judges should engage in cross-training and follow binding coordination protocols. Hence, both Sharia and civil judges can sit on the bench. Fourth, to align all family laws with the CRC, to nullify unilateral conversions, to prioritize the welfare of the child, and to educate parents about their legal rights. Lastly, to invest in public education. Parents should be informed about their rights and legal procedures to avoid being manipulated and misled. And what are the way forwards? Looking at the way forward, we need strong political will and judicial cooperation to fix overlapping jurisdictions. Most importantly, we need to take a child-centric approach in every case. As I said, the child's welfare must be prioritized above all else. In conclusion, I would like to propose several matters that the authorities must take into action. The remedies for Malaysia's jurisdictional conflicts lie not in confrontation, but in structured collaboration between its dual legal system. Legal reforms must be harmonized, Sharia and civil laws, while upholding CRC principles, ensuring no child is caught in a tug of war between courts. And normally, when decision was made, it is between the two different parents. One is as a Muslim and the others as non-Muslim. By institutionalizing joint tribunals, mandating dual consent and entering every decision on the child's welfare, Malaysia can transform its legal pluralism into strength rather a weakness. Only through unity in diversity can the nation guarantee justice and protection for its vulnerable citizens. As I must say, with regard to this, the most important part, whatsoever decision, whatsoever that action that we can take, the welfare of a child is paramount above all. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Associate Prof. Datuk Dr. Muhammad Azam Muhammad Adil. Very fruitful, very insightful, precise, and very absolute. So we are here to gather some of the questions that's been raised from the audience. If I may read to you, Associate Prof. So the first question is, how can Malaysia's dual legal system be harmonized to ensure the rights and welfare of minors are uniformly protected in cases of religious conversions? Question number 2, to what extent should parental rights under Sharia law be subject to civil court review in interfaith custody and conversion disputes involving minors? Thank you, Associate Prof.
Okay, thank you, Mr. Nur Bakri. To answer that question, I think I have been, as I have presented before, I think the problem they are facing in Malaysia, because number one, we have dual systems. the civil and the Sharia system, the civil and the Sharia laws. Okay. The problem arises when one of the parties converted to Islam. In the first place, they were non-Muslims. They entered into civil marriage under this Law Reform Marriage and Divorce Act 1976. So that is the normal cases for non-Muslims. What happened throughout the years, one of the parties converted to Islam, and this is the big problem arises. What happened here is normally the cases, the Muslim party will seek from the Sharia courts the conversion of her or his children, the minor child. And this the problem arises. Under the present systems, under this Law Reform Marriage and Divorce Act 1976, with regard to the conversion of minors, there's nothing in that circumstances that provided in the law. What happens here is both parties, the Muslim and non-Muslim parties, either the father or mother, they go to the different court system to seek justice or to seek remedies. The problem here is under our constitutions, Article 12, Clause 4, which I did not mention in my presentation just now. It says that determinations of a religion of a minor, so a minor which has been concluded in our presentation below 18, a minor. What happened here is under this provision under Article 12, Clause 4, it means that it must be determined by parent. By parent. So what happened here is interpretation of the word parent. Is it singular or is it plural? So according to the interpretation by the courts, so we have several cases that was reported and that were held. Several cases that were reported and held, there are different approaches, different interpretation. But the landmark case by Indra Kadri persists until now that a consent must be taken into both parents, means both father and mother must give consent. And this has been the line of what the cases that brought before the court after the Indra Gandhi case until what I have also shared just now under this, the recent case of Loh Siu Hong that the beginning, from Perlis, etc., etc. So how can we harmonize these two laws? And that is the big things. And after the amendment of this Law Reform Marriage and Divorce Act 1976, in particular Section 51, that gives the Muslim parties to file a petition to divorce and to get all sorts of the, what we call it, solutions, etc., at the civil court, because they entered their marriage at the first place from the civil laws. So they have to go back to the civil court to seek remedies. If we were to abide with this dual system, I'm no longer obliged to go to the civil courts because I'm Muslims now. But don't forget that initially, you were non-Muslims and you entered the marriage under the civil laws. And you cannot escape by not, going to the civil court to get all the remedies, because you can't solve the problems if one of the parties go to the Sharia courts and the other party go to the civil court. There must be a meeting point. So the authorities try to meet this meeting point where non-Muslims cannot go to the Sharia court because it has no jurisdiction over the non-Muslims. So where are the parties must go? So they have to go to the civil courts, despite he or she is now a Muslim, because taking into consideration where the marriage was formed under the civil laws. So this is one of the issues that I think that we can try to rule out so that there is a remedy. Okay. Now, the conversion of the minors. At the moment, we have also a big problem because one of the parties can convert the minors, the children of theirs, to Islam. If we allow that provision to take place, then there is no solutions because it gives the big problems to the system itself. As we can see now, after decision by Indira Gandhi, after decision by Subhashini, after the decision by law, we cannot solve the problems. So I propose through my research and my writings that we cannot leave it to the court to decide. We need to go beyond the system of the courts to set up a tribunal, to set up what we call a mediation system where it involves parties of both, from the father, from the mother of the different faiths, and also a third party, and experts and others, to reconcile, to meet together for the benefit of the children. Put aside the ego. I am the father, I can decide, despite the father is a Muslim. Put an ego that I'm a mother, I have over the right of the children. So this, I think, perhaps can be resolved if we can have a third option rather than the court decision to determine the conversion of the minors as well as the custody for both further interest, the welfare of the child. Let's assure whether it is the civil system or the Sharia system, if you go and read a lot, the benefit, the welfare of the child is paramount above everything. And that is also discussed in many of the books written by the jurists in Islamic classical books. I don't know whether I have answered all the questions. You have two questions, but I have answered perhaps both of the questions in my answer just now.
Thank you, Dato', for this very insightful, very precise, and I think we have three keynotes that we can incur and embrace for these sessions. So number one is understanding, inclusivity, and of course the collaborations. Thank you all for joining today's webinar. We truly appreciate your time, attention, and active participation. A sincere thanks to our distinguished speaker, Associate Prof. Dato' Dr. Muhammad Azam Muhammad Adil for his valuable contributions, as well as TV Ikim and TV Ikram for the essential role in making this event happen. Finally, thank you again, ladies and gentlemen, for your participations. It's your involvement that brings this webinar to life, and we are fortunate to have such an engaged and dynamic group with us today. Wassalamualaikum warahmatullahi wabarakatuh, and have a good day.